quickly. Should I use an AR contract or a CAR win form? What are the differences?
Good morning, everybody. Just to start off, many of you probably know me as Holly Thomas, so I just wanted to clarify, Holly Barberi, same person, okay? I just finally made the switch and changed my name officially, so same person. And so with respect to the CAR and the ARR, when you're talking about a commercial transaction, so I'm not talking about investment residential property, but a true commercial transaction where you're talking about retail space, industrial space, the AIR form is really pro-seller. So if you are the buyer, the AIR form may not be where you want to go, but the seller may require you to put it on an AIR form because it really is pro-seller. The CAR forms are a lot more, I would say, balanced, but many sellers believe they're really pro-buyer because everything gives buyer sort of the power over the contingency periods and the power over whether or not they're going to put the deposit in, and everything is very active on the part of the buyer. So it really depends on which side you're representing, on which side you're going to try to roll for. The CPA, the commercial purchase agreement, is really set up for less complicated transactions, I would say. If you have anything that's a more complicated kind of a property that involves heavy environmental, lots of tenants, lots of personal property that's going to be committed to the purchase, really the AIR form is your better choice. There's a lot more flexibility in the contract, a lot more ability to be able to add and subtract, as you know, to delete and to add phrases. The CAR forms, they don't yet let you do that. It's not that Zip Forms doesn't have the ability, but the CAR has turned that all off. So, and then for properties when there's no lease back, no owner occupancy issues, AIR doesn't really support that as well. So that's really the form you want to stay away from if you're going to be dealing with, well, I'm buying a commercial property, but it has also some residential units, and I'm going to owner occupy that. Then you probably want to start looking back at the CAR form because there's forms that are already built in for that kind of issue, whereas AIR doesn't support the leaseback owner occupancy. So, and then, personal property, really you want to be careful about that because AIR can set you up on adding an addendum, but neither of those forms deal very well with selling personal property, inventory of any kind, furnishings, equipment that's not fixtures. Neither form really deals with that in a way that I think make people, particularly realtors, very happy. So.
Thank you, Holly. Blake, back to you. Regarding landlord-tenant issues, if a landlord or a tenant is a business entity, is an attorney required to initiate eviction?
It's a great question. Not big on this. Sorry. Is this better? Yeah. Not as annoying. Sorry about that. Sometimes I ask when I come and I give talks here, I like to ask the crowd, what do you think the answer is? Do you need an attorney? You sure do. If you're a business entity and you're defending or initiating a lawsuit, you do need an attorney, and that's real good for us up here as attorneys. Not so good as maybe your clients, right? Who are looking to purchase a property with an LLC, whether it's an income property or otherwise for estate planning purposes as well. There's a few different reasons for that that are all helpful to attorneys, not to everyday people. Really, the underlying thought is that they don't want business entities to be practicing unauthorized practice of law. Now, you might think about that and say, well, any person who goes pro se, they could be practicing unauthorized practice of law, but they make a difference here for LLCs and corporations, and they say that you do have to have an attorney involved. I had a case where we were suing commercial tenancy for non-payment of rent, and a little bit better? Thank you, sir. We were suing him for non-payment of rent. When he filed his answer, again, the tenant was a commercial tenancy. He filed it as an individual. Court still set it for trial. We show up the day of court. and I explained to the judge that we've got a corporation here that we're suing who is appearing as an individual, and he doesn't have an attorney. And as a double whammy, on the Secretary of State's website, he hadn't paid his fees, so it was also suspended. So both reasons why he could not appear on behalf of his corporation. He could not lawyer up the day of because he couldn't practice on unauthorized practice of law, hadn't paid his dues, and we got a default against him. He had to sit there and watch us finish it up. So something to be thinking about.
Thank you, Blake. Bill, let's talk about entities. So pick one and roll with it. Thank you.
Good morning, everyone. My name is William Clark, and I'm a real estate attorney practicing in Redondo Beach. Here today, I'd like to talk about entities that are frequently used for real estate for asset protection. Limited partnerships are obviously one of those, but that only is for protection of the limited partner, and according to if it's properly formed and set up correctly, then that would mean that the limited partner would just lose his investment. But what I really wanted to bring to focus is corporations, limited liability companies, and trusts. First and foremost, if you form a corporation, you should know there's 3 tiers. First, you have to have shareholders of that corporation. You have to have directors of that corporation. And then finally, you have to have officers of that corporation. So there's different layers of ownership and people that are supposed to be involved. However, there are sole one-owner corporations. They own all the shares. They're the only directors, and they're the only officers. However, for asset protection, that can be considered not quite important enough to go ahead and allow that corporation to maintain its status as a separate entity. And then we get into issues, what's called piercing the corporate veil, and going after the organizer, the shareholder, the person who formed the corporation, and then making them individually liable. Most accountants would not recommend owning a property in a corporation because they typically would end up likely paying more taxes. They'd have to pay a corporate tax rate, and then when they pay the money to themselves for whatever reason in the way of a distribution and so forth, then they'd probably have to pay individual tax on that as well. So because of more expenses, likely more tax, and certainly more paperwork, corporations are not typically recommended for owning real estate. The next type of entity that is used very frequently now is a limited liability company. Those basically came into existence through the state of California legislator, I don't know, 10 or 12 years ago, it seems, at least that long ago. A limited liability company only needs two different types of people. One is a manager of that limited liability company, and the other is a member. Many times, once again, you can have a sole individual person as the manager and the member, but once again, we'll get into it later that they can pierce the LLC veil to go after that individual. It is typically considered the best type of entity to own investment real estate. And then finally, we have trusts. A lot of people are trying to do trusts now for commercial property. Clearly for family or residential property, trusts are typically used, and people put their family trust and put the real estate into the name of the family trust. That trust has to be revocable, which means that it can be changed by the trustor and the trustee. It's not a permanent situation, so that property or residence can be taken out of that trust, and it does not provide any asset protection if it is a revocable trust. And any kind of asset protection would really be only if it is irrevocable, meaning you can't change it, you can't take any of the property out. But it's really not, trusts aren't really set up even in that regard, and they're better for just transferring property to different family members and different, from grandparents to grandchildren or from parents to children, and a irrevocable trust is best for things like that.
Thank you, Bill. Holly, back to you. So regarding the AR, CAR forms, how are the remedies for buyer and sellers different under these two forms of contract if there is a breach?
So just to kind of walk through what happens in both contracts, right? If there's a problem and there's a dispute, you guys are the first line of defense. So the first or under either contract, if there's an issue, is agent negotiation, right? You guys are going to try to negotiate with the other side through the other agent. Hopefully there's an agent on the other side when there's a dispute, and try to find some middle ground for them. If that doesn't work, then mediation is standard in the CAR forms, but not existent in the AIR forms. So I don't know if you guys realize that, but mediation in the CAR forms is not optional, right? You guys don't, there's nothing to sign to put yourselves in or out. It is always a part of every CAR form. And I hear you guys say this all the time, and I say you guys because it's a realtor problem where you say mediation, arbitration, mediation, arbitration, mediation, arbitration, and those are two completely separate things. They are not the same, they're not even similar, and so don't put them together, okay? Mediation exists in the CAR forms, it does not exist in the AIR forms. Mediation is optional only to the extent of when you go, nobody's going to force you to make a decision. So both sides are going to go, there's going to be a mediator, he or she is going to float back and forth between both parties and try to convince them that their case is better or worse, usually worse than what they think it is, and with their lawyer's assistance, help them to pull the emotion out of it and find some sort of resolution that both parties, or however many parties there are, can come to an agreement and then walk away and feel like, okay, I'm done. That is a very useful tool. I would say probably 90% of the mediations that I've been to have settled at mediation. That's a high number. So I strongly recommend that even if mediation isn't a requirement under the contract that your clients have used, that somebody say, hey, maybe we should try mediation. Under AIR, agent negotiation, and then the next option that you go to is either arbitration or court. So that's a big leap. So there's no middle ground of like, hey, isn't there something that's a little bit cheaper for us to try? Mediation is it, but it's not a forced requirement under AIR, okay? So arbitration then, either arbitration or court. Arbitration if you've signed into it, because California requires that you have to initial the paragraph to be able to force everybody to go into that. And then the other thing that exists is liquidated damages. Liquidated damages, let me just tell you what the rule is, because in my experience, most real estate agents don't actually know what the rule of liquidated damages is. Liquidated damages says that if the buyer breaches, that means that they have committed to the contract, they don't have any contingencies to walk away from, they don't have a right to walk away, and they walk away anyway, right? So the buyer breaches, then the seller has the right to take all of the deposit, whatever that number is. On a commercial transaction, that could be a pretty high number. If you did a 10% deposit, that could be a really high number, okay? The exception to that rule, that's the general rule, everything on deposit. The exception to that is if it's a 1-to-4 unit and the buyer is going to own or occupy, that maxes out at 3%. But that's the exception. And that's not that big of a percentage of our transactions, and it's certainly almost never a commercial transaction because commercial is not 1-to-4 unit. So it doesn't apply to multifamily, doesn't apply to mixed use. So your standard for liquidated damages is the entire deposit. So if you're on the buy side, you better think about that for your buyer on how much you're actually putting down, because the entire deposit goes to risk if they all agree to liquidated damages. Okay?
Thank you, Holly. Blake, back to you. So what are the two key differences in a legal requirement for a commercial 3-day notice of non-payment compared to a residential one?
Well, we could start with the easy one, right? For residential, they have the precise sum rent due, right? You have to say specifically what the rent is. Now, this is something that I hear from realtors who sometimes representing their clients, certainly owners of properties who have income properties. What's something they might put into a 3-day notice other than rent? Late fees, right? If you're by contract, you owe a late fee. If you don't pay by 5 days, sometimes it's $50, sometimes it's a percentage, and sometimes they include interest. All right, with 3-day notices for residential leases, you cannot include that. And what happens if you do?
It's not a notice.
It's not a notice, it's defective. And when is somebody going to tell you that it's defective?
Way down the line.
All right, it could be 2 months later in front of the judge who looks at the lease or the notice and says, hey, this is what the rent amount is, but did you include a late fee? Yes, we did. And they say defective notice, and they kick you out, and you start all over again. Okay, so residential, very serious. For commercial, not as serious, all right? There's a lot more leeway. They call it the amount of the rent claimed has to be reasonably estimated, okay? And why would we do that? Because sometimes the rent depends on a lot of other things, right? It could depend on your CAM, it could depend on your revenues. Just depending on the deal, it'll tell you how you come up with it. And so the law is a lot more lenient with the commercial tenancies for the landlord to come up with what the rent is. Now, as a baseline rule, you have to come up with something, right? And as I just told you, if it's defective, they'll throw you out. So you want to be thinking about, we got to come up with a reasonable number. And so if at the end of the day, they take a look at the number and you're in front of the judge and they say that the amount that you put in the 3-day notice was not more than 20% than what it was supposed to be, then they say that that was reasonable. All right, so it can be up to 20% more than what it should have been. So again, obviously a lot more leeway than with the residential. Also with the commercial tenancy, when you have those issues with coming up with what the rent is, even if you get it wrong, it's not going to be automatically invalidated. You could still have your day in court. Just something to think about with the commercial tenancies, more leeway than the residential.
Thank you, Blake. Bill, which one?
The issue about asset protection and what kind of entity to use really boils down to the definition of alter ego. If you make a claim against an entity like a corporation or an LLC, and you don't think that entity has any money, then you're going to have to look at the person who formed it, who operates it, and who is really behind that entity. And what the bottom line is, the entity or the corporation or LLC is really the alter ego of the person who formed the company, has the money, and is doing the operation. So that is what alter ego means. There's a primary test for this that the courts look at. And one of them is that there's such a unity of ownership and operation between the corporation and an individual that it doesn't really exist that they're separate. So that's one little test. The next test is that a fraud or inequitable result will result if you allow the separateness of the individual and the entity to exist. In other words, you'll sue the entity, you should win the case, there should be money, but the individual took all the money out, and so there would be a fraud or a bad result if you allowed the entity and the individual to be separate. It gets more complicated than that because through the years, courts have decided all the different types of things that the judge should look at to determine if the entity should be pierced and the individual should be held responsible. I have 15 different things that a court is supposed to consider in determining whether they should pierce the LLC veil and let the individual or make the individual be responsible for any claims or damages and so forth. So one of the first elements is, was there commingling of money or other assets or a failure to segregate money between the individual and the entity? And many times that happens. I have a case right now where a fella, remodels, fix and flip, put it in an LLC, but he took money from the LLC and he used it to build a jacuzzi in his personal residence backyard. That's an excellent example of doing something you're not supposed to do, commingling funds from the entity for your own personal use, and he didn't really segregate the money and keep the money for the entity separate from the money from his individual self. And so that's number one. The other next element is to treatment of individual assets as that of the company, or vice versa. You treat the company's assets as the same as yours. You can't really do that, and the court's going to look at that. And the third one I wanted to say is you failed to do the proper paperwork and issue shares of stock or have a manager with an agent for service of process and all those that paperwork stuff that your attorney would normally do for you. If you shortcut it and you don't have that kind of paperwork done and completed and properly dated, that too is another reason the judge will allow the piercing of the LLC or the corporate veil.
Thank you, Bill. Back to you, Holly. So, is it legal to have passive removal of contingencies?
So this goes back again to the AIR versus CAR form. The AIR form has passive removal of contingencies. That means when the contingency period ends, they automatically go away, And if the buyer isn't ready to get rid of their contingencies, then they have to cancel, otherwise they lose the contingencies. The CAR form is an active removal of contingencies, that the contingencies continue and continue and continue until close of escrow, unless the buyer actively removes it with a signature. So people regularly that are accustomed to using CAR forms, they get to the AIR form or they get to a builder form and they're like, this is not legal. They can't make this just automatically go away. Because you're so used to one form, that doesn't make the other form illegal, it just makes it different. So passive removal of contingencies is perfectly legal in the state of California. There are a lot of standardized forms that use it. A lot of builders use it. The old REO forms that we had, what was that, like 12 years ago, we had all those REO forms. Passive removal of contingency is perfectly legal. But the issue that comes up is that agents don't realize that outside of the CAR forms, most forms are passive removal, and you don't read it ahead of time, so then you get into a gotcha moment where your clients weren't ready to have it removed, but the time frame expired, and now they don't have that contingency anymore. So when you get a form that's not something that you've looked at before, it's not a form that you're familiar with, even if it's an AIR form and you've seen those before, please make sure that you read through the form. You can't give your client legal advice. I can't tell you how many times I'm going to say that to you. You cannot give your client legal advice, but you can put together a schedule of days, right? Most companies, either within your brokerage or your title company friends or your escrow, you can put together a schedule of dates. And as you're going through and putting through that schedule of dates of everything that's important for that transaction, you can note whether that's going to be a passive removal or an active removal. And that way your client is aware that that's a hard deadline for them. I either have to get out or I'm in. And once I'm in, particularly on passive removal, then you fall back into the, liquidated, you can breach the contract if you walk away. And I do want to just mention that I didn't mention before, because liquidated damages is when the buyer breaches, but there is a remedy when the seller breaches. When the seller decides they don't want to sell anymore, and that's specific performance, where the buyer gets to bring an action against the seller to say, no, you have to perform under this contract. Just like there's a difference between residential and commercial in evictions, there's a difference between residential and commercial when it comes to specific performance, because the law says that every home is very unique. And so I can force you to sell your home to me if I have a contract on that home and you breach the contract, seller, because there's no other home that looks or feels like that home. So the buyers can get a specific performance action against a seller on a residential property. On commercial, the law sees that commercial properties are kind of one and the same. Oh, you're going to have this building, but you can have that building, and it's going to be this, as long as the cash flow is the same, well, then it's the same building. And it may not be for you, because that building may be 2 hours away from where you are, and you only like to buy buildings that are within an hour's drive of your house. But as far as the law is concerned, specific performance is rarely enforced in commercial. You get damages instead, because every building in commercial can be replaced by another building. So I just want to make sure we hit both sides of that buyer breaching or seller breaching.
Thank you, Holly. Back to you, Blake. So how does serving a commercial tenant differ than a residential tenant in a practical sense?
So for both residential or commercial, we're talking, the normal ways of service are personal service, right? You hand it to them directly. You do it substituted service. You give it to somebody who's over 18 at the place where the tenant is supposed to be. They accept it on their behalf. Or you do a nail and mail, right? We can't find them. We post it on the property, and then we mail it to them. Now, what Bill was talking about, what's important is to make sure that all your paperwork is kosher. Let's say you've got a corporate or a corporate tenant, and if they're filing with the Secretary of State their statement of information, what's one of the things that they got to put on there?
Agent for service and process.
There you go. Lawyers love those guys, because that means you're putting somebody who we can find, we have to be able to find to serve them with the paperwork. That's somebody you've nominated to accept service on your behalf with the corporation if a lawsuit is to follow. So it's really easy with the corporate tenant. If they're an LLC or corporation, you're going to know where to find and serve them. Now, in a practical sense, if it's a person or it's a resident, right, what's sometimes what these tenants like to do? They'll hide. They won't answer the door. Okay, and that's fine. There are ways to deal with them. With residential tenants, if you normally with our process server, if they try 3 times at 3 different times a day at different days, you can ask the court for an order, an application in order to post, and the judge will actually give you the authority to just post it at the property. Now, there's a legal consequence for serving a tenant in this way, and if you do it this way, yes, you didn't have to find them, but it's also not going to apply to unnamed occupants. And what's an unnamed occupant? Kids. Could be kids. It could be somebody who says that they've been subleasing to. They're not named in the lawsuit because you didn't know about them. But at the end of the eviction, if you win, it's not going to apply to unnamed occupants. And then what did you get? You got a sheriff who's doing a lockout and leaving behind people that are still on the property. And I had a case where it was a commercial property that was purchased. It was an income property, and the tenant was not a corporation. It was just a person. Immediately stops paying rent. So before talking to an attorney, they serve them with a 3-day notice. They start the lawsuit. By the time that an answer was filed, that's when they said, hey, we need to lawyer up. And I take a look at how they served them, and what they failed to do was serve them with something called a prejudgment claim of right to possession, which is what you need to serve them with to make sure you can deal with the unnamed occupants. I pointed this out to them. I said we should start over. We got to make sure we deal with them. And they said, no, we're not going to do it. So I put it into writing, and we continued it and moved ahead without fixing it. But because of that, it wasn't done properly, that the unnamed occupants were served, and then people started appearing in the lawsuit. There were 2 other gentlemen who filed answers who said, hey, we actually live at this commercial property. Okay, and because we hadn't properly served them or defaulted them out, because I was told that we should not worry about that, it created a lot of problems. And this is one of the gnarliest cases that I dealt with in terms of games playing and time wasting, that the day before trial, one of the tenants filed for bankruptcy. Okay, and what happens if you file for bankruptcy? Everything stops. There's an automatic stay. I've told the story in here before, so I'll cut to the end, but it took 7 months. There were 4 different bankruptcies filed by these 4 different tenants, every time the day before trial. And then by the end of it, the judge, he overused his authority. He honestly shouldn't have helped me out in the way that he did, but he saw the games playing, and because the tenants weren't showing up and they kept filing for it, he did give us the default against them. We were able to get them out. But again, paying attention to those details, making sure we're properly serving them and finding them can be real helpful in finishing the job.
Thank you, Blake. Bill, back to you.
All right, to go on with other elements in order to pierce the LLC or the corporate veil and hold the individual liable, if that individual holds themselves out as personally liable for the debts of the corporation or the LLC, then that's an element that the judge would look at and say, no, you can't have the protection of the LLC or the corporation. For corporation, if you fail to maintain minutes and corporate records, the judge could decide to hold the person individually liable. Another issue is if people have multiple entities and they own those multiple entities to do basically the same thing. We find that a lot where there are LLCs to own and remodel this property, and there are LLCs to own and operate a different property, but yet they mix and match money, and money goes back and forth between the 2 of them while they're remodeling 2 different properties at the same time, but they're separate entities. The same use of the same office or business location for the same owners or employees. Lots of companies have multiple names and companies all under the same address. I find that a lot in the South Bay, where there's a real estate office, an LLC, a corporation, another real estate office, and so forth, where one individual basically is controlling 5 different entities, all out of the same office, and that doesn't fly well. A big one is to fail to adequately capitalize and not put enough money into that entity in order to do the things it's supposed to be doing. So if you are going to do a fix and flip and remodel, you need to capitalize that entity with enough money to do that fix and flip and be responsible for any problems that would come up and so on and so forth during the course of the remodel. and then ultimately thereafter. The courts also look to see if a corporation or LLC is used only for a single venture. And like I just said, a lot of times people will form an LLC for each property they're remodeling, and the court isn't going to consider that very good and likely hold the individual responsible when there's just so many multiple different entities instead of one entity doing several remodels.
So just to follow up on Bill's saying, there are lots of CAR forms, as many of you know. But one of the things that he mentioned was when you are acting as an individual and not as the entity. I think I heard you say something like that. So that's when you sign for something for yourself and you don't include the corporate name along with that. So this happens a lot when agents draft purchase agreements for their clients when they have a trust, and you sign it, you have them write it just as Holly Barberi, but you don't write that it's Holly Barberi, comma, trustee. So you really need to make sure that that's how you're writing up the contracts and the disclosures, and then you add the extra form, the representative capacity signature disclosures, right? The RCSD, there's 4 of them, buyer, seller, landlord, tenant. So you really need to make sure you're including that. That goes for corporations, LLCs, partnerships, trusts, powers of attorney, and estates. So all of those are listed on there, and then you write up your client as Holly Barberi, comma, trustee, Holly Barberi, comma, executor. Now, if you're doing an LLC or a corporation, then that's the entity name that goes on the purchase agreement, and then the RCSD says, oh, I'm the person that's signing on behalf. But it's really important that you don't get stuck into what Bill was just talking about, where your client is just signing as an individual, and they're actually representing something else, because otherwise you're putting your own assets on the line instead of the corporate assets.
Thanks, Holly. This question, actually, there are 2 people here that called me over the past week to ask me specifically this question. This one happens all the time. How do I get paid as a commercial agent when the listing is not on the MLS, it's on LoopNet or CoStar?
Right. So, as a realtor and as a member of the board, with your access to the MLS, probably, well, many of you are probably old enough with me to know why the MLS exists, but why does the MLS exist? It is for commission. That's really the whole purpose that the MLS exists in the first place, is for broker compensation. The fact that they have all those pretty property pictures and tell you all the information about how many beds and baths, that's just extra. The real reason the MLS exists is to pay you as a co-broker, right? But that's not why LoopNet and CoStar exist. They exist to get information about properties out to the public and out to other real estate agents. So when you understand that the purpose of the entity is different, then you understand that they don't offer compensation. So the fact that there's a property listed there does not mean that you are going to get paid. So if you find a property or your client finds a property on LoopNet or CoStar, you have to figure out how you're going to get paid as a part of that. Now, all of you know that CAR does not include compensation as a part of the purchase agreements. It has come out of that, I don't know, it's been decades now, it hasn't been in the purchase agreement. So you either rely on the MLS, co-broker compensation offering, or you include a cooperating broker compensation form, a CBC. You have to stop me if I just start putting out names, lists of initials for CAR forms. Or you do a commission agreement, a CA form, or you can use a single party compensation form. That's an SP, I think. Single party compensation, that's for a very specific purchaser. And so if you're doing a CoStar or a LoopNet, you need to make sure that you're getting those documents signed before you submit your offer, because if you don't get it signed before you submit your offer, then you've submitted your offer and they go, oh, thanks, great, we'll take the offer, forget about you. The other option for you is to have a buyer representation agreement with your buyer. There are 3 different types in the CAR forms. You only want to look at 2 of them. One's the BRE, that's the exclusive, buyer representation exclusive. The other's the BRNE, the buyer representation non-exclusive. Don't use the NN form, it's the not for nothing. It's the non-exclusive non-compensation, so you definitely don't want to use that one. But if your buyer's going to pay the piece to you and you don't care whether the seller's going to pay you, then use the BRE form that you are their exclusive agent. You can list out the properties that you've shown them, and then they can make an offer, and you don't care if the seller is going to sign anything. Now, if the seller ends up paying you something, then it goes against what the buyer is going to pay you, so that's a bonus, because then the buyer pays less to you. But at least you've been paid by somebody, because otherwise you're working for free. And we all know you work for free darn often enough, okay? That you absolutely don't need to be doing that when you're actually showing a property and you're selling a property to somebody. So make sure that you're taking care of your own compensation simultaneously, but preferably before you put the offer together to go and put it on a LoopNet or a CoStar property.
Thank you, Holly. So those two who called me last week, always call, somehow find out how they're going to pay you before you give them the name. They have access to LexisNexis. All they need is her name, and they can find out everything about her. They don't need you anymore. I'm telling you, it happens. Back to Blake. So what happens if a commercial landlord accepts partial payment of rent after the expiration of the 3-day notice for a non-payment of rent?
So this is another problem I see a lot in the residential arena. In the commercial arena, it's not as big of a problem, because a lot of the times that the lease is going to say that if we accept rent after the service of a 3-day notice, in the commercial leases, it could be applied towards CAM. It could be applied towards the late charges. It's going to be in there. So there's a lot more leeway for the commercial landlords to do it. Now, in the residential realm, that's absolutely not the case, okay? And this is another one that at the end of the day, if you end up in front of the judge and you have to tell them that you've accepted rent after the expiration of a 3-day notice, you're in trouble. I had a client who the day of trial, I met the attorney for the tenant that we were trying to evict for non-payment of rent, and he showed me a check that was deposited into my client's account that he had never shown me before. And I had to walk over to him and say, you need to settle this right now, because if you don't, we're going to be back here in 2 months. Because yes, they owe for all those other months, but we included in the 3-day notice that they hadn't paid that month. That's a problem. Now, obviously, that's just not knowing the facts, because the client hadn't told me it. Sometimes what else I've told clients is that, look, do not allow your tenants to directly deposit money into your accounts, okay? I had a client who, I told him that, and he had, it was his personal checking account. And I said, well, that just doesn't make sense to begin with, but if that's what you're doing, you need to shut it down, because after the 3-day notice, they're going to deposit money, and we're back to the beginning. And he made me put it in writing. He came to his senses and he shut it down, okay? Now, about a few weeks before trial, he had opened up a new account at that same branch. And what happened was the tenant went to the bank and said, hey, I want to deposit some of it. I think at that point they had owed like $3,000 and she was going to offer him $800, thanks. But she couldn't find the account because it had been shut down. And she went to the teller and said, hey, I'm a tenant and I'm just trying to deposit rent. And the teller said, oh, it looks like you shut down that account. And the tenant said, well, can you help me find the new one? And the tenant said, sure. Or sorry, the teller said, sure. And gave her the information for the new account to then deposit it into his new account. They cannot do that. And so I turned to my client and I said, well, two things. We might have just lost this case, all right, and we might have to start a new one because they should not have disclosed that information. Now, thankfully, we settled it. And normally what happens in these, you show up the day of court, we work out something with the payment plan, and they get out. It's easier for everybody because you never know. I tell my clients, sometimes the judge is having a bad day, and then we're having a bad day, okay? So if we work something out, let's work it out. And that's how that one ended up. But that was one where my client had done the right thing, and his institution almost messed up the whole case for him. And so making sure that not accepting that rent payment after the expiration is huge.
Can I just also throw out there the 60-day notice?
Sure.
Because I just yesterday had an agent call and say, my client gave the 60-day notice and the tenants needed a little more time. And I said, well, what did you do? Well, we just gave them more time. Well, did you extend the lease or the 60-day notice? No, we just gave them more time. So my response was, well, now you get to do a new 60-day notice because they accepted rent after the 60-day notice expired. That's true, right?
Yep.
Yeah.
They continued the lease, so you had to start all over again. Mm-hmm. No good deed, you guys. No good deed.
That's the bottom line.
Thank you, Blake. So I've run into this many, many times that my clients are asking, can we just get the tenants to just deposit the money directly and all that stuff? And you hear it left and right. Never ask your clients to do that. They like the fact that it's all digital, that they just deposit. But I had a client, $14,000 of rent in South Redondo right now, today. They didn't pay, and then when they went to file, they deposited $1. So did they pay rent? Yeah, they paid partial rent. But it created, I mean, the attorneys were loving it because that's just what it was. But I'm just going to tell you, the best suggestion is probably just tell your clients, ask for a check. You take the check, you deposit it. Then you know exactly what you've got. But a lot of people are busy and they're asking, I'm just busy. If they can just directly deposit it, it works great. It works great if they deposit it. That's all. My 2 cents. Bill, back to you.
So another thing a judge will look at in order to determine if an entity or an individual is responsible is if there's a disregard of legal formalities and failure to maintain arm's length relationships between the individual and the entity or multiple entities. A good example of this is loans of money. Oftentimes, a company will receive a loan of money from the individual owner, but no one created a promissory note, no one had a due date, no one had an interest rate, the corporation or LLC never made a payment back to the owner or the individual. And that also goes with multiple entities loaning money back and forth between each other without promissory notes, without a due date, without a repayment, and so on and so forth. I've used that element of to get after the individual owner many times in court, and it's the judge really looks pretty harshly when people don't maintain those kind of formalities. Another issue is the diversion of assets by the LLC or the corporation, or manipulation of assets. One example I already gave you was using corporate money to build a jacuzzi in the person's backyard at his residence. Another is, of course, as soon as the fix and flip is done, escrow closes, the money goes into the LLC, and a week later, all the money comes out and goes into the owner's pocket. That's really a diversion of assets of the LLC or the corporation. It really just shows it was all just a sham to have an LLC as the owner and seller of a property, and as soon as that's done, the cash goes right into the actual individual's pocket. Another is the formation use of a corporation to transfer it to existing liability of another person or entity. Same kind of thing where you're just using that entity or shell to go ahead and put the liability of a fix and flip and so forth on that entity and not the individual. And that's why everybody does it. They think, okay, if I form an LLC, then I won't be personally liable. And if there's construction defects and, the place leaks, the windows leak, the foundations crack, whatever it is that causes the new homeowner damages, they're really just trying to shift the liability to the LLC and then throw their hands up and go, well, the LLC has no money. Sorry, you can't sue me. Goodbye. And until they get through all these elements, and most of the time I'm able to find some big mistakes in the way they started, formed, and then ultimately operated that corporation and LLC to get to where the real money is, and that's the individual.
Thank you, Bill. Holly, back to you. So what's the biggest ethical issue for commercial agents?
So the biggest ethical issue that I see that really strikes more on commercial side than on the residential side is agents that represent a client and then buy the property from the client. Or they're selling their own property and they represent the buyer who's buying their property from them. So I have a 4-finger rule, and there's quite a few people in here who have been one of my agents before. So my 4-finger rule is we have the buyer, we have the buyer's agent, we have the seller's agent, and we have the seller. You may be 2 fingers and they have to be next to each other. Okay, so you can be the buyer and be the buyer's agent, right? You can be the buyer's agent and the seller's agent. You can be the seller's agent representing yourself as a seller, but you can't be the seller, represent yourself as a seller, and represent the buyer, because it's an automatic conflict of interest when you are selling your property and you are representing the buyer. Remember that as an agent, your fiduciary duty is that your actions have to be in the best interest of your client. So if you are the buyer's agent, representing them on the purchase of your property, there is no way that you can stand there with a straight face and look me in the eye and tell me that everything you're doing is in the best interest of your buyer when you are the seller. It just can't happen. And they just say, well, but I only own 5%. Like, I don't care. You're looking out for your bottom line. And if you stand there and tell me, well, no, I'm going to be looking out for my buyer, I can't believe that. That's like when my 5-year-old is standing there with red stamping on his shirt, and I'm looking at the wall, and it's on the wall, and he says, I don't know who did that. I mean, it's the same thing. He literally did that to me last night. It's the same thing, right? If you own anything of the property, and then you turn around and try to represent the buyer, it's an automatic conflict of interest. Same thing when you have the listing, and then you don't understand why nobody wants to buy it because you think it's a great deal. So you're going to buy it from your client while you represent your seller. That's a conflict of interest. And all of that can be solved, right? You just bring somebody else in, right? If you are the seller, then don't represent the buyer. Let them be represented by another agent. What are you worried about? You already offered it out for sale. You were already ready to spend the commission. Well, but I could save money. Yeah, and then you can be sued, right? Or you think it's a great listing, you don't understand why nobody's buying it, you want to buy it, great. Relieve yourself of the listing, bring in another agent, you can get a referral fee. That's okay. You can get a referral fee on the side. But you can't be the agent interacting with the client anymore. You have to let the listing go, let the seller have another agent, stop talking to them because now you're the buyer and they're represented by somebody else. It's okay, but you cannot be more than 2 fingers that touch. And just as an example, it works for anybody in the transaction. We had a seller one time who wanted to buy. Notice how many fingers are between there, okay? It was a trustee of a trust who wanted to actually buy the property. Well, they had to resign as the trustee, and then they could buy the property. Because again, conflict of interest. They had a fiduciary duty to the beneficiaries, to the trust, to everything act in the best interest of the trust. You can't do that and then turn around and go, well, I'm going to negotiate with myself perfectly great to be the best buyer out there. Right? It doesn't work. So 4-finger rule works for anybody in the transaction. You may only be 2 fingers, and they have to be next to each other.
Thank you, Holly. This next question has come up many, many times lately. Blake, so what's a concern for a commercial landlord may have regarding renting to a tenant running a cannabis operation?
Yeah, so I've come here a few times and talked about what's going on here in California with the cannabis businesses, and this one is related to bankruptcy concerns. And I'll water down some of the bankruptcy references. I'm not a bankruptcy attorney, but this was one that was actually decided just a couple months ago in May, Garvin versus Cook Investments Northwest. And so essentially what happened is there was a commercial landlord who was filing for Chapter 11 reorganization, bankruptcy. At the time, the landlord was accepting rent under a written lease with a cannabis business in Nevada. Now, in any kind of bankruptcy, right, you have to propose it to the trustee. And anybody know who the trustee works for? The government. All right, and it's actually an arm of the Department of Justice. And so what's still illegal under federal law? All right, selling marijuana. So there's obviously states that are taking a different take on it. California's one of them. And in Nevada, this is an issue that was brought up. And the bankruptcy court confirmed the reorganization, but the the trustee appealed. And what was his argument, right? The rule is that a company that seeks relief under Chapter 11 bankruptcy can get a plan if the proposed plan in good faith is proposed and not by any means forbidden by law. So what was the argument, right? The The argument is that they're accepting rent. It's a written lease with a cannabis business that's illegal. And they said the landlord is renting the property to a tenant engaged in the cannabis business can't meet the test because he derives income from an illegal enterprise. It's a pretty clever argument, kind of scary. And at that time, when it was being argued, there was no precedent. There was no controlling law. And this is something that's still being figured out today, how federal law is going to catch up with what's going on with the state laws. And what happened in May? Anybody want to guess?
So the idea was the landlord couldn't have them continue to operate the business to get the rent because the business was illegal?
Exactly. And what they were doing is that he was still accepting the rent because he had terminated the lease, but they still had a right to possession at the time that it was going on. So there were some technical issues in what was going on, and what they pushed back on was to say that, well, that portion, this rule about not accepting rent forbidden by law, it was really more about how the plan was created. Again, more bankruptcy stuff that you don't want to talk to me about. But obviously, and I, as Mo had mentioned, I've been asked too. We're dealing with here in California what we're going to be doing with these types of clients of yours who might be looking to rent to the cannabis business. And what the ruling is that they ruled in favor of the landlord, okay? And this happened just in May. And they said they affirmed the reorganization plan. It said that the plan was lawfully proposed even though the lessee was illegally growing marijuana. Now, it's huge because this was done in the Ninth Circuit. It's not controlling law. It's not binding for other jurisdictions, but it's certainly persuasive. And so this just happened in May that these commercial landlords that are looking to do this, because anybody could be thinking about it, right? Life happens and you might need to file for bankruptcy, but if you have somebody who's looking to open up this commercial property but knows that if they're renting to a cannabis business, and then, right, bankruptcy is federal code. So if the federal law is not going to support you, you might be thinking twice. But here in the Ninth Circuit, which includes California, we just have this controlling here under the Ninth Circuit that the landlords are protected.
I will tell you from a real estate commission standpoint, there is no law out there yet that says that you're okay to be collecting a commission on a transaction that involves marijuana. It is still illegal under federal law. It is not illegal under California law under most conditions. There are still a few. So whether or not you're collecting commission on the purchase or sale of a cannabis business or on a piece of land that is growing marijuana, it's up in the air as to whether you are aiding and abetting, whether you're in a conspiracy. All of those things continue to be tossed around. I mean, the fact that these businesses have to operate under cash because the banks are federally chartered, and so the charter doesn't allow for them to do anything that's illegal under federal law, so they all operate on cash. Are you laundering money when you accept a commission that was paid through a cannabis business? It's all big, huge question marks in the real estate legal community because we just don't know. So my recommendation to agents that are in my brokerage are always get a referral fee. Hand it off, get a referral fee from the other agent, let somebody else take that liability, and don't have that liability under your brokerage.
I have a marijuana story as well. Mine is older, and I just wanted you to understand it. I represented a shopping center owner who got a letter from the Department of Justice saying marijuana sales are happening at your shopping center. That is illegal under federal law, and therefore we are going to take your shopping center away from you. And she was not happy about that idea, so she retained me to try to stop that process. I worked long and hard with the tenant because we wanted the tenant to stay. They were paying outrageous rent. It was nuts. And the federal attorney general and the FBI agent that were involved, they kept telling me and sending me letters, oh no, we're going to, you can't do it. We're going to take your property and so on and so forth. So I started the eviction. And then the marijuana shop, of course, they defended the eviction. We paid our rent. We still have a lease. We haven't done anything wrong, blah, blah, blah. And so it was really getting to be quite a tough case, lots of money being spent. And then right before the trial date, the FBI and the Department of Justice changed their mind, and that's because we had a change of presidents from Bush to Obama. So Obama backed off the federal enforcement of that eviction, or the DOJ that he's in charge of, and so on and so forth. And because he just, I don't know if it's an executive order or what he did or what he said to the Department of Justice of, we're not going to try and enforce those legal federal rights against, pot shops in California. I do not know what the present situation is. I haven't heard
I've
anything.
been actually kind of surprised because I expected there to be a change and a shift in that after the presidential election a couple years ago, and I haven't seen that change.
Yeah, I think it's
But
still
I
pretty
think it's
relaxed, is
still-
what I think it is.
I think it's up in the air, though. I mean, with this president, one never knows, so,
Well, and we
We
don't
could
know
get a
what
tweet this
Attorney General
afternoon.
Barr is going to do compared to the prior Attorney General. I mean, each Attorney General could make a new decision about what to do about pot shops, and in any state, whether they're legal or not, they still do have federal authority to do what they want to do. But I haven't heard anything or know of any, taking of shopping centers or commercial property because there was a marijuana distribution
not
shop.
recently.
Yeah,
Not
I haven't heard
recently.
anything like
Yeah.
that, so.
But on residential, I don't know if you're going to talk about this, Blake, so maybe I'm overgoing that, but I have heard that you will not get an eviction under residential for a resident that is using marijuana or growing marijuana, even though that's quote-unquote illegal under federal law, because an eviction is state law. Is that true?
That sounds right. And normally, the leases that you have don't address it, so you may not even have a breach of covenant in there. That's why I tell my clients, if it's something that you're concerned about, you're going to want to update them for the residential leases, because likely the smoking, smoking's not going to apply, but for growing, it's also likely not going to apply.
Great. Bill?
Well, I really don't have any other issues to talk about the elements to pierce the LLC veil or the corporation. So I'm wondering, is a question out there that somebody wants? Yes.
About the marijuana, we had a listing in Riverside, which is not considered in the marijuana area, but apparently there's a lot of growers that are out in this industrial area. Our client did not want any marijuana in her facility, but we got constant emails from lawyers that were working with clients, and they sent 10, 15, 20-page documents that were, you had to be a lawyer to really read through the letters, but they're all stating that there's no way the feds can take it, your properties, do this and do that. It's really kind of convoluted in a way because you're trying to read through this, and it's difficult, but it is an ongoing, with just this one building that we must have had 20 inquiries from all outside entities coming in for marijuana, manufacturing, production, the whole 9 yards. So if you have listings in those areas, you're going to be constantly bombarded by lawyers. And they send out, and it looks great when you're reading through it, gosh, this is perfect. But just like you said, it is so still up in the air that it's a tough one.
I think there's two things to that. One, the amount of money they're willing to pay. It's hard for a landlord or a seller to say no. It's the numbers they're willing to put out there. Your client was saying,
huge amount of
it's
rent.
exorbitant. You're getting 3-4 times what the rent should be. But the other thing is, you're talking about lawyers, right? It is up in the air. So that lawyer is looking for there to be some sense of normalcy. So if their client ends up getting sued, they get to take that forward, and then they'll keep moving it forward so that they can get a ruling of some sort. So in their book, it's a win-win either way. So, I agree. I think that your client is being very safe to say, you know what, I don't want that.
Our rent was $12,500, and we had people come in, we will pay you a year in advance, and we'll give you $15,500.
Yeah.
And all cash, and your client's going to do what with that? Now she has to go to the bank. She has to try to deposit all that cash. That creates a whole nother set of conversation with the bank, because when you try to deposit more than $10,000 in cash, they want to know where did it come from. You got to fill out this whole form. And there's lawyers that are doing regular business with cannabis industry, and they have to go through this whole process. I don't know if you guys have been to any seminars lately with any lawyers that are doing that, but there's a whole niche industry in the lawyer community that's coming up with that.
This company also was being traded on the stock exchange in Canada. So, we're talking a $100-something million company, which is operating, everything's legal, and still it's that one little element that it is not legal.
Yeah, it's a little more than one little element,
I know.
but yeah.
Next question. Raise your hand if you have any questions for Eric. None?
Wow, we were astounding
Well,
today.
I have one. I've got to ask all the attorneys. We've talked about this many, many times. Some of you may have been here. I want to talk about, give them your understanding of dual agency. We've talked about this many, many times. This, and the way they put it out, it would make sense. This is a pet peeve of mine, but I just want to talk about that. I know sometimes you guys are being dual agent. You may not know exactly how that works out. I'm just going to talk about it for a minute.
So dual agency, as I mentioned already, right, your fiduciary duty is to act in the best interest of your client. So if you are a dual agent, remember there's two kinds of dual agencies, right? There's dual agency across the brokerage. So everybody in your brokerage is a dual agent with the other agents in that brokerage. So if you represent one side and someone else in your brokerage represents the other side, that's dual agency. Most people don't have an issue with that because you are clearly going to represent your client and the other party is clearly going to represent the other client. But by law, they are still under one brokerage, and the broker is dual agency. The dual agency that most people have problems with is when you, single human, represent the buyer and you represent the seller. Because somehow you have to figure out how to represent each of them in their best interests at the same time, which is a very tricky line to walk, but it is walkable most of the time. You have to keep in mind, though, at some point in at least one transaction that you do, they are not going to see eye to eye. And when they are no longer walking in the same direction together, they're no longer saying, you know what, my goal is to sell this property, and the buyer's goal is to buy this property, but let's say the seller has decided, I don't want to sell, and the buyer still wants to buy, you now have a conflict. Because the best interest of your seller is to figure out how to get your seller out of the transaction, and the best interest of your buyer is to get your buyer to close the deal, and now they're not the same goal. So you, just like a neutral escrow company, you have to stop. You can no longer keep moving the deal forward because now you're violating your fiduciary duty against one of your clients. And I think the hardest thing for agents is to realize that sometimes the thing you have to do is nothing. You guys talk too much. You do too much. When you hit that point in the transaction, first of all, you should have already had that conversation with your clients up front. Look, I'm going to be a dual agent. This may happen in this transaction where I get to a point where I cannot do anything anymore, and you will feel like I'm acting in the other side's best interest, but I'm not. I just can't do anything else because it will be going against you or it will be going against them, and I have to stop. And at that point, often what happens is they have to get a lawyer because there's only one agent, or you get them into a mediation where the mediator can negotiate something in between them. What happens if you keep moving is eventually they get a lawyer anyway, and then both lawyers point at you, and then you give up your commission because you already violated fiduciary duty, so rather than being sued, you give up your commission and they figure out how to make the deal go away or close. Or more, right? The other thing to think about is confirmation of agency. That's in the CAR form, it's paragraph 2. In the AR form, it's way back towards the end, which I'm shocked at how far back it is. But the confirmation of agency, where you set out who the listing broker is, who the listing agent is, who the buyer broker is, and who the buyer agent is. Notice I've changed my language because the CAR form changed their language, right? So the seller's agent, seller's broker, buyer's agent, buyer's broker, you have to list those, but the boxes are what are important. And if you don't get the boxes checked correctly, then the penalty is your commission. Can I say that again? If you don't check the boxes correctly, the penalty is your commission. So if you don't tell everybody up front, hey, my broker represents both parties, and you mark the box for seller only and for buyer only because you only represent the seller and somebody else only represents the buyer, it doesn't matter. The brokerage is the same, so you have to check the both buyer and seller boxes, and if you don't do that, both of your commissions gone. The seller could have grace and give it to you anyway, but they don't have to by law. The law says even if you're all hunky-dory at the end, they can still get to the end and go, sorry, don't feel like it. And there isn't anything that your lawyer or your broker can do for you because the law says they don't have to pay it. So the key is if you did it wrong, fix it. You can fix it. There's a CAR form for that. It's called the Agency Confirmation Form. It's an AC. It looks exactly like paragraph 2 on its own little form. Just have it filled out correctly, get both sides to sign it, and boom, voila, your commission is no longer at risk. Best form ever for you.
Thank you. Blake?
Oh, yeah. I would just, I mean, Holly's certainly the expert on this stuff, but I'll just say as an anecdote, and I know nobody in here would do it, but I had friends of my wife's down in San Diego. They purchased a property. There was a dual agent, and one of the due diligence aspects they were doing is they ran camera snake through the pipes to make sure everything was good. The agent oversaw it and made sure that it showed that everything was clean. They'd been living there for about 2 weeks, and then the pipes exploded, and their place was flooded with stuff from the sewers, and then they had to get somebody else to get in there and fix it, and when they went back into those same pipes where we had seen the video to show that they were clean, they found the snake camera broken in it. So then, okay, so that didn't work out, so then they gave them video from a different one, which is real nice, and so I'm telling them, go clean up your place, deal with all that, and then we'll talk about where the lawsuit comes. But to Holly's point, if nothing bad happens, then the dual agency is great for everybody. But when is it ever that easy? And it takes one little thing where the dual agency, you're going to find yourself in a conflict where you can't be loyal to both sides, and you find yourself in the middle. I think in this case, if they decide to move forward with it, they're going to find, right, that they saw that it wasn't going to pass. They tried to cover it up, which certainly makes things worse, but fix it. Just address it. You could reduce the price, just disclose it, and you can move on. But when you try to Band-Aid it in that way, things certainly get a lot worse.
In our industry, we call that disbarment.
Right. See you later.
Bill?
You know, I've had a lot of agents come to me and talk about representing both the buyer and the seller, and I always recommend strongly against it. To me, it just seems like a built-in conflict of interest that you can't get around. And even though it seems like the buyer's happy, the seller's happy, and everything worked out, and you got that wonderful double pop, full 5%, oh boy, easy money, you know, in a year from now, 2 years from now, whenever anybody gets angry, the fingers are going to get pointed at you. I've seen it time and again, and it's just a lawsuit waiting to happen. And it's unfortunate, but I really recommend you try and stay away from that. Even if the deal goes smooth, who knows what's going to be happening in a year from now, and you're going to be named, you're going to be looked at, and it's nothing but trouble.
You guys, is there something going on in the state of California to actually stop dual agency?
Well, there's a lot of states that have made it illegal and have considered it illegal, and I hear things all the time of, oh, California's going to enact a law and make it illegal as well, but I don't think it's ever been done yet. It's still talk.
So
But other states have done it.
I can tell you that the real estate brokerage down in San Diego that put the big push to have commercial agents have to do the agency disclosure, because that was new, it was about almost 2 years now. That brokerage has been pushing to eliminate dual agency because they only represent one party, they don't represent both. I think they only represent buyers. And so for them, it's a great idea, right? Because we only represent one side, so we should definitely get rid of dual agency. It doesn't seem to be getting any gas anywhere. The only thing that I could see happening in the future for California is no single human dual agency. I don't see them eliminating dual agency across brokerages, but I do see them at some point in the future looking at eliminating single human dual agency. That's not near future, that's sometime in the future, so.
Thank you. Questions? Eric?
Can we discuss a little bit about LOIs, primarily the compensation part, which we discussed before, how you can protect yourself, because we've had many times where we have an LOI, and is an LOI technically, is it non-binding, really? We've had a couple times where we've sent LOIs out to ownership, and we don't hear back from them at all. And we contact our client and find out that our client has a lease in hand already. And they've gone completely around us and sent the lease directly to our client and kind of weeded us out, all based off, I mean, these are smaller deals, but still, so we have to go and backtrack and Luckily, we have clients that actually have called us and said, I've got the lease already, I need you to discuss this with me. And I'm like, we haven't even gotten the signed LOI back. How did you get the lease? And primarily, how do they even find who that client is? I mean, we sat down and discussed the build out for them, and they exchanged phone numbers. So we are weeded out of the deal. Luckily, as I said, we do have some good clients that did mention to us, and we discussed it with them. We did get paid towards the end, but how do we really protect ourselves in the LOI situation? Does it technically need to be signed by both parties? It's non-binding, but how binding really is it?
So you have a lot packed into there, so let me see if I can break that down a little bit. So one, I've been a real estate lawyer for many years, and we used to use LOIs back when I was in private practice. I'm sure that Bill sees those a lot. I hate them. I think they're great in theory because it finishes the whole counteroffer back and forth. But you have this problem that comes up. So, and if they're written by the broker, not by the client, then you don't have the authority to be speaking on behalf of your client. So now you've said my client's interested in a lease or a purchase at this price and these terms. But then if they actually put that together and send it over, your client's now going to negotiate that. So it's not really any kind of a commitment of any kind. And if your client signs it, you always include language in there that says this is not binding. This is just an agreement to go and discuss and negotiate some further agreement. And an agreement to agree is nothing. So, so letter of intent is just nothing, right? Yeah. I mean, I think that if you want to try to get rid of the potential issue, you can send a nice letter that says, I have this client, don't tell them who that is, that would be interested in leasing your property or purchasing your property on these terms. Who would I speak with? Is this something that you guys would even talk with me about? I'd love a conversation. And that way you force them to call you. The other way to handle it is what we already talked about for compensation is you need to get your client signed with you to pay you if they buy or sell or lease, the other way, and then you offset that with anything that you get from the other side. The other option is, hey, I'm going to send you this information, but you also attach a commission agreement because if it's a single party commission agreement, look, and I'll provide the name to you after you've agreed to it. Or you create the single party agreement and then I'll attach an addendum to it and state in there the addendum is going to be attached within 5 days after full execution of what the name is. So, you have to look out and protect yourself so that they don't work around you because it's a problem.
Would you send the CA even if you're working off of AIR?
Yeah, absolutely. You can mix and match forms like that.
The lead guys hate that.
They do, but you know what? If they want to have their own commission agreement, tell them to send you their commission agreement. Why don't you get your client to sign it, put my name on it, give me your form, and I'll take it and we'll sign it, we'll be done. Right? Because if they don't want your CAR form, AIR doesn't have one. So, until they decide to come up with something, then, we're kind of stuck with what they have. So if Lee wants to put together their own or M&M wants to put together their own, great. We'll sign their form. No problem. You don't want to look at our CAR form. Yeah.
Thank you. Next. For anybody, any concerns you have on pocket listing? Any thoughts you have on pocket listing? Sorry. For any of the attorneys, do you have any thoughts on pocket listings, things we should be aware of, don't do?
I have lots to talk about, but I certainly don't want to overrun anybody else.
I just think in a nutshell, you have to make sure that your client, the seller, really knows what you're doing in the way of, keeping the listing kind of hush-hush and not trying to disclose it to the world, not putting it on the MLS, and trying to keep it, among just people in your office and so on and so forth. So it's just making sure that your client, the seller, truly knows what you're doing with their listing, for the first 2 weeks or the first month or whatever it is that you're trying to accomplish while it's a pocket listing.
Yeah, and I completely agree with that, and I think it goes both directions, right? Because a lot of times you hear of something and you bring your buyer and you've been told, look, if you'll pay this number, we won't put it on the MLS and we'll deal with you. So I think it goes both ways. I live in Manhattan Beach, and for whatever reason, a high percentage of single-family homes there are being sold off-market. I think that there's a lot of reasons why the clients make the choice to do that, and some of those reasons are perfectly valid, right? They have a name that's very well known, and they don't want people trudging through their house and seeing their family photos and going, oh, I was in so-and-so's house. Other people, They just don't want traffic through their home. They don't want a public open house. They don't want a broker's open. They want it to be very quiet. There's other people who are like, you know what, I got a lot of crap in my house, and I'm not interested in, I mean, I'll be honest that 5 years ago we bought our home off market. But I'm married to a realtor, so he knew about it coming. It was coming. It wasn't supposed to be off market. And the people that sold us were like, great family, blah, blah, I have a great family. And they didn't want to have to clean up their house. They knew it had been 17 years they'd lived there, and they just didn't want to do any work to it. And so for them, it was a great option because they didn't have to spend some money to get more money, and the money wasn't really what they were doing because they were building their own house somewhere else. So there are lots of reasons why people choose to, on their own terms, not put it on the market. But when it's the agent making the choice not to put it on the market, then I have a real issue with that. Because as Bill already pointed out, you need to be looking out for your client. And if the goal is, well, I want to sell it within my own brokerage, or worse yet, I want to sell it on my own, then you're not looking out for the client's best interest. There's just no reason that you should be making the decision for your client that it shouldn't be going on the market. It's one thing to say, we're going to sign this listing, and we're going to change out the carpet, and we're going to repaint the walls, and we're going to put in some pretty flowers on the front. We're going to do some cosmetic changes because curb appeal right now is really poor, and we're going to spruce it up a bit. So we're going to have it signed. We're going to have it on waiver, but that means we're not doing any marketing, right? We're not going to be talking about it with anybody. We are just going to be doing the things we need to be doing. We're not putting a sign out in the yard. And we've marked the little box B on the CRMLS waiver that says we're not doing any of those other things because the client is fixing up the property. And then you go on the market and you have a DOM of 0. There I go again, days on market of 0, right? Because nobody knows about it. That's not a pocket listing. That's just we're sprucing up and I'm protecting myself so that nobody comes and knocks on the front door and says, hey, pretty flowers, are you selling? That way they say, well, yes, I am, but Luann is my agent and you need to come and talk with her. Here's her card. Okay, so that's protecting yourself, but also protecting your client, making sure. I mean, really the only way to know that the house is getting the number it should have is putting it out in the open market. I mean, it just is what it is.
I have a kind of an interesting story on a case I just finished working on that kind of comes up with that pocket listing, and that's because a buyer interested in a house wanted to go ahead and buy it before it went on the open market and before it was on the MLS. The asking price on the listing was $1,995,000. But in order to avoid the open house and all that, this buyer decided to pay $2.3. Big bump. Well, what happened is this buyer went out and got partners to help him buy this $2,300,000 house because they were going to do the fix and flip. Well, when my client found out that the property was originally offered at $1,995,000 and was up to $2.3, he obviously got very upset with his partner who brought him into the deal and never told him, well, we kind of overpaid at $2.3 and we probably could have got it for the listing price and so on and so forth. So that pocket listing really created some real frustration and a lawsuit between the partners when one partner found out that they kind of overpaid for this property that was listed at, or going to be, sold at a much lower price.
Any other questions? Oh,
Are there any law that non-binding contract has to be, it has to be non-binding? Why not is going to be binding? I never write any LOI which is non-binding. I get the permission from the seller and buyer initially, and I always write LOI binding, so we don't have any problem.
So the problem with writing an LOI that's binding is that essentially you have a purchase agreement now. So if they do not come to an agreement on a purchase agreement in the future, then the buyer can still go back to the LOI and say, well, I didn't like any of those terms you put in the purchase agreement. I'm just going to go back to here. California law and many other states say that as long as you have the material terms for a purchase and the person against whom you're going to enforce it has signed it, that can be a contract. So it could be on a beverage napkin as long as you've written the property description, you've written the purchase price, the close of escrow date, and the seller has signed it. That could be a purchase agreement.
Yes.
And all the other terms are really superfluous as far as the law is concerned. It may not be superfluous to the buyer and the seller, but it is to the law. So when you write an LOI that's binding, potentially, one, you're practicing law without a license, and two, you may be putting your seller, if you're representing the seller or you're representing the buyer, in a space where they don't actually want to be tied to the purchase. They don't have any due diligence rights. They don't have any contingencies to get out. They're now bound to buy or sell.
But there is no law as such, right?
There is no law as such. There is law that supports that if you have an LOI and it has the material terms, that it can be binding against the party that signs it.
Because I think, there are so many things you can iron out during LOI.
Yeah, you can have a 20-page LOI, but then why don't you have a purchase agreement? Why aren't you just offering the purchase agreement out?
Because during commercial property, I think seller always prefer LOI.
I think that that's a stretch to make that assumption.
Yeah.
I think if you put a purchase agreement out there that's 20 pages versus putting an 8-page LOI, I think you're just as strong the seller can ignore either one or they
Yes.
can respond. So I think if your goal is to have a binding, then why don't you do it as an offer?
Thank you.
I have a property that I managed. The owner of the property, for about 3 months prior to me finding the tenant, was asking me to get the house ready, find a suitable tenant. And he would not sign me a management agreement form. His inducement was, find me a tenant and I'll give you a 5% during the duration of the lease. I went ahead and did it, looked around, located a tenant, and the property leased for $6,900 a month. He signed the lease directly with the tenant, so the two of them signed the deal. And 3 weeks later, he fires me, saying that, oh, you don't return calls, I can't trust you. His whole intent was to just use me to get a tenant and move me on. Well, a few months afterwards, the tenant stopped paying his rent because the owner refused to replace the carpet that had moldy smell and all this other stuff. By the time the tenant moved out, that owner made a false police report saying the house was destroyed, damaged, blah, blah, blah. And he gets the insurance to pay out originally $73,000. The tenant did not trust this owner one bit. He videotaped the entire place prior to moving, so he has that video. This owner is suing me for $10,000 in small claims court. This Friday, I got a hearing court, and his claim is that I owe him a fiduciary obligation. He said he did a background check on this tenant, and the tenant was his reports were clean. He had $230,000 in the bank for the prior 3 months as a self-employed person. I thought he was good. So how am I liable now for $10,000? I got total paid.
So I think there's two things going on. One, you have property management that you do separately
Yes.
from your brokerage work. I know that. So as an agent, if you don't have a property management company, then you better not be managing, okay? Property managing has to be done under a broker license. So unless you are your own broker's license, then you better check with your broker to make sure that your broker's okay with you doing property management. Most of the larger brokerage companies are not okay with that. They usually don't have E&O to cover that. So you need to make sure you're checking on that. The beginning part of the conversation or the statement was really about not getting yourself compensated, right? Making sure that you have a listing, a lease listing, so that at least you get paid for the lease. You're trying to get the management, that's separate, right? You can try to do that. But if you're an agent and you're trying to get a tenant for a client, remember that you are not the landlord, so you should not be making the decision about who the tenant should be. Your job is to provide qualified tenants under your estimation to the landlord, and then the landlord makes a decision. My recommendation is, and you could certainly speak up to this, is that your landlord should have a list of what the qualifications are that they want, and that list better be objective, not subjective. So how much income do they want? How long do they need to have been at their job? How much money should they have in the bank? You know, how long have they lived at their last location? If it hasn't been long enough, then how long were they at the location before that? You know, they need to have specific objective qualifications. And then when you get tenant applications, you know, CAR has one of the benefits that they have. Do you remember what the credit check thing is that they have? Rent spree, thank you. Comes up on my Facebook feed all the time. Rent spree, and you guys can, basically you send out the email to the prospective tenant, the prospective tenant fills everything in, and the package comes back to you. So they don't have the ability to doctor anything because it doesn't go to them, it comes to you. You take the package, you put it all together with your CAR forms, you can do it all through zip forms, I believe, and then you send it over to the landlord and you give them all the applications together. And then you could have some sort of a little thing that says they meet this qualification, you know, these 4 out of your 5, and by the way, I've noticed this. Or you could say, you know, they only meet 3, but they have this other issue that might make them a better tenant option for you. So you can give them your opinion, but in the end, that package needs to be reviewed by the landlord, who then makes their own decision so that they're not making the claim that you did something wrong and you had a fiduciary duty. Now, as far as for you, I mean, this sounds like this guy's got his own issues and you're just the scapegoat for that. You know, I can tell you at small claims court, it's a crapshoot, it's a roll of the dice every time you go. So, you know, you need to look like you're the most prepared, you're the most professional, and don't argue with the judge.
I do have a question on that. Do you have it in writing that you were supposed to get a commission for the leasing of the property to the tenant?
I did not get in right. He would not give me anything in writing. Give me at least a management agreement form. Verbally, he said, which turned out to be $345 a month, which then he chewed me down to $300 a month when everything was all said and done.
But you didn't have a commission, a lease commission agreement with him at all, though, is that
No.
right?
Nope.
Okay. I was going to recommend you file a cross-complaint. If you had that written lease commission agreement, then I'd file a cross-complaint against the guy and really make the small claims case a mess.
The management agreement form was not checked on the box that said either party can cancel with a 30-day written notice. That was not checked. So he had a 2-year lease that I could
So then
actually
you
be
can cross-complain
entitled
for
for.
that.
At least
a
argue
commission.
that. Tell him you wrongful termination of your property management agreement and that he owes you money for all the months that you haven't been paid that $300 or whatever you negotiated with him.
The lease was executed on a 2-year lease with the tenant. He actually distanced myself from this transaction because we knew that the tenant wanted to buy the house for $2 million. And when the tenant moved out, 7 months later, the house got sold for $2.4 from another buyer.
Well, bring up your property management agreement and the fact that the seller, the person breached it, and that you're entitled to compensation. But I think you need to get a cross-complaint filed with the small claims court.
I was going to do that after this Friday.
No, you have to do it before.
Before.
Before, for sure.
Because wouldn't he be able to challenge if he loses?
No, you got to bring all claims and issues between the parties are supposed to be resolved in one small claims case. You're not allowed to have multiple down the road later on.
I was told that if he loses, he could go out and retry it again. If I lose, I get a second chance with an attorney in small claims.
Well, that's an appeal process. That's a different question.
Issue, you don't get to bring up new stuff.
Right.
So if you want to talk about new stuff, you got to file it now before Friday.
And better hurry.
Right.
Today.
I had no
Like really, today.
Yeah, I know.
I don't know what the time.
I had
cutoff
no
is for
intent to
cross-complaint.
chase him down for that lost commission. It was 2 years ago. And I just, after reviewing all the documents, I discovered, hey, I never checked off that box.
I'd still file my cross complaint and muddy the waters at the small claims hearing.
Okay.
Yeah, I don't know.
Any more questions?
Question for LLC. You say for real estate, people own the real estate, different property should have LLC. It's the best way to
For LLC, yeah. I'm with you now. Question?
Yeah, and then, I heard somebody say each individual property should have one LLC, is that right?
No, I think that that causes a problem, actually, when you have multiple LLCs for every project, every remodel, every property. It's better, and the judge will think better of the LLC if that LLC has ongoing business, ongoing activity, ongoing properties, and so on and so forth. So it's better to not have the multiple.
I quickly throw in there's the legal and then there's the practical. Each LLC that you have to pay the minimum tax, each doesn't have a tax return. There's also a lot more money out of your pocket associated with it.
Thank you.
George?
On a couple occasions, I've represented, national or international companies on the sale of their property, and what they would want is, at first an LLC, and my client, I was representing the seller, they would, once we received an LLC from anybody, they would, LOI, an LOI, they would draft their own LOI, which they would send back, and they would, once that was accepted, one of the conditions was their attorney, the seller's attorney, would draft the purchase agreement, and they made a requirement that the buyer be represented, by an attorney also. But they took me, basically out of the loop as far as any further negotiation during that drafting of the agreement until, acceptance and so forth. And I got paid at the end. But just as a broker, is there anything that I would really need to watch out for in that type of circumstance?
So it's kind of funny, when I was in private practice and dealt with very large companies doing very large real estate transactions, and we'd have commercial agents come involved, and I'd sit there and I'd look at the closing statement. I'd think, they got paid for what? What did they do? I'm the one that did all the work. But, now that I'm on the other side, I see, well, it took you forever to get those people together, right? It took you forever to convince them that it was the right choice to sell that property. And then, so now I know why you guys get paid that money. But as a real estate attorney, it was funny because I was the person doing all this drafting. The thing you need to make sure you do is, again, make sure you've checked all of your compensation boxes, right? Do you have a listing agreement? Do you have a compensation agreement? A lot of times commercial agents do it off a handshake, and a handshake is not enforceable. So if you don't have some sort of compensation agreement with your client, I mean, even if it's the email between you and the director of real estate sales at that company, and that's the guy who has the authority to be able to sign the compensation agreement, then you have an email and he's going back and forth and you saying, yep, negotiating, and you finally get a, yep, we're going to pay that for you. I'll make sure that the attorney puts it in the final purchase agreement, because in that situation, usually the purchase agreement talks about the compensation to the agents as well. At least you have something that's signed by the party that has the authority to do it. The specific terms are in there, and then you have something that's potentially enforceable. But really, your better choice is to have an actual commission agreement or a listing agreement signed.
Well, I did have a listing agreement with the company.
Uh-huh.
But just because I was out of the loop during all the negotiations.
That's just bonus for you. Less work, you still get paid. Yeah, less work, but you still get paid. But it's still in the back of your mind as like a black cloud of like, what's happening and where am I doing and who am I supposed to be taking care of? And you want to ask questions, but not ask too many questions, because you don't want to be the gnat. You just want to be the fly on the wall. And, it's a little bit of a fine line for you guys as the broker in that kind of a transaction. Mm-hmm.
One last little thing. When we send out leases to our clients for signatures, we drafted up a little document that just basically says, we advise you to use a lawyer to go through the documents and we have a checkbox that you've accepted and a sign underneath it that yes, you're going to have a lawyer, or no, you're not going to have a lawyer. We've never had to use that. We don't even know if it's even binding or anything. We don't even know if it could protect us, but we just like to make it clear to our clients that here's a lease. We're not, lawyers. We advise you to have a lawyer review your lease. Sometimes we get resistance on it just because we're like, well, isn't that your job? Aren't you supposed to go through it? Yes, we're going through it, but I don't have I can't legally, answer some of the questions that you're asking. And so we do send it out, and some sign it saying yes, some say no, but we don't know if that's going to help us if there was ever a problem with especially if they signed yes, our lawyer has reviewed the documents. Is this something that you see people are doing now?
Actually, I've not seen that. I think that's an interesting idea. I think that your response to your clients can be, yes, I've reviewed it from the real estate brokerage perspective, but I can't look at it from the legal perspective because obviously I'm not a lawyer. I can't say that, but you can say that. And so, I think that you need to, strongly underscore that with your clients and remind them that they should not just have their lawyer look at it, but they should have their accountant look at it as well. Because there's lots of spaces in there where it talks about capital expenditures that are going to be then pushed down the lease, and does their accountant feel okay with that? Particularly if you're on the landlord side, but even if you're on the tenant side, do those CAMs look like something that we can squeeze into our budget? Are they, So I think that you should include the accountant in there just the same. I mean, that's a boilerplate question.
I think
we
it's a
put
pretty
into
good idea,
contracts.
good protection for you, to have that form, and it puts your client on notice that they should consider having a lawyer look at the lease as well. So I think it's a good idea, and I think it's good protection for you.
We got scared a couple of years ago that our client said, well, don't you have a lawyer just sitting there? No, I don't have a lawyer, but he's not looking at
So I have that problem because I am a lawyer and I work for Vista Sotheby's, and so I am in-house counsel, and so people make the assumption that I'm reviewing your client's stuff for them, and I always have to go back and say, I don't represent your client. Make sure your client understands I represent the brokerage, so whenever I give responses, it's always in representing the brokerage and the agent. And so, it is a problem for me that I do have to say, well, I am a lawyer, but I don't represent you. And if you want your own interpretation, you need to get that from your own attorney.
Two more.
We need your business cards.
That's all I want. I work for Vista Sotheby's, yes. I used to be at Remax Estate Properties, so some of you may know me from there. But I did. I mean, just as a side note, I did move in February. So.
One last question, right here.
Okay. I have a question. If I'm part of the LP, if I'm the part of owner, belong to one group as a LP, if I collect the rent and the LP kind of compensate me, do I have to let my broker involved since I'm...
Oh, that's a question about property management?
Yeah.
So you cannot be considered property managing of your own property. No, that's not what I'm saying. You are not a property manager if you are managing your own property. Okay? You can all day long manage your own property and you will never be considered a property manager. Or, well, no,
when you
if you're the
manage someone else's
landlord.
property
It's
that
when you
has-
manage somebody else's property that you're considered a property manager. So as long as you own just a little tiny bit of it, you are an owner and you are managing your own property, even if you're doing it on behalf of everybody else. As long as you have some ownership, then you're fine. It's when you manage my property that you have a problem. Then the DRE says, "Whoa, what are you doing? That's practicing real estate without a license." Yeah. And I just had that conversation with my twin sister the other day, who is now getting her license because she's property managing.
In the back?
Last one.
Do you own any of it? No. You personally own any of it?
Not yet.
No, not yet. But what I did just hear you sneak in there was you're the trustee of the trust, and the trust is the owner. So you are actually the representative capacity for the owner. So then you're okay because you're acting as the trustee, as the manager of that property. So you are the owner. But if dad owns it as dad individually, then you are a property manager. So there is a little distinction because you are an owner as the trustee. It's like being the president of the corporation. You're not managing somebody else's property, it's your property. You are part of the ownership. Is that?
Yeah, okay, thank you. A question following up on that. If I'm licensed, when he dies, do I need to disclose that I'm an agent on the sale of the property?
Anytime you have ownership and you are buying or selling, You have to disclose that. The DRE requires that you say, one of the sellers, or the seller, in your case, one of the sellers, in your case it'd be the seller, is a licensed real estate agent. Yep, always, always. Or seller is related to the listing agent, or listing agent is related to one of the sellers, right? Those are mandatory disclosures, and if you don't do those up front in the purchase agreement, you better fix it fast. Because when that comes out sometime later on, almost at the close of escrow, you got bad blood going. Yep. Yeah.
Well, thank you guys all for coming. Thank you for our panel. Appreciate you guys' time. Thanks again.